Welcome to the deep dive. Today, we're opening up a file that, honestly, it reads more like a corporate thriller than a standard legal dispute.
It really does.
Our mission is to take this stack of legal documents, all this expert analysis, and get to the bottom of the monumental clash between the New York Times and OpenAI.
And this is so much more than just a dispute over, data fees or something simple.
Right.
We are looking at a lawsuit that, because of some very recent developments, threatens to cost the entire artificial intelligence industry billions. And not just that.
No.
It could potentially overturn the foundational legal rules for how every major AI model is trained. I mean, every single one, from GPT to Google's models, all over the world.
Okay, so the initial conflict, that part seems pretty easy to grasp. The New York Times, other big publishers, they're suing OpenAI for what they call mass copyright infringement.
Yep.
They're alleging that all their valuable proprietary journalism was basically scraped wholesale to build the brains of these huge, profitable models like GPT.
That's the core offense, absolutely. But the core defense was, at least initially, seen as equally powerful. When this lawsuit first hit, the overwhelming consensus in the AI industry and among legal scholars was that OpenAI had a pretty clear path to victory.
And that path runs directly through one of the most important ideas in all of intellectual property law, which is fair use.
Precisely. Fair use is this crucial exception in U.S. copyright law. It lets you make limited use of copyrighted material without getting permission, as long as that use is transformative.
Transformative? Like for criticism or news reporting?
Exactly. Criticism, news reporting, scholarship, teaching. And according to all the source material, legally, the AI industry was seen as being very much in the right to invoke this for training.
Okay, let's just deepen that for a second, because understanding how strong their original case was is, I think, critical to appreciating the drama that comes next. Why was everyone so confident they would win on fair use? What was the main pillar of that argument?
Well, they leaned entirely on that concept you mentioned, transformative use. Courts generally look at four main factors for fair use, but the first one, the purpose and character of the use, that's the big one.
Okay.
So when you or I read an article, we transform that information into general knowledge. We don't, usually remember the text word for word.
And that transformation from the text into just sort of human knowledge, that was the perfect analogy for what an AI model does. Is that it?
It was elegant, simple, and technically pretty accurate. The central legal justification was this. AI training is the machine equivalent of a human reading a copyrighted work and then synthesizing what they read.
So it's not memorizing.
It's not supposed to be. The model is learning the probabilistic relationships between words, syntax, style. It's not just storing and recalling the original text to spit it back out.
So if the model isn't just regurgitating the work, but it's using it to learn grammar and concepts, like a student reading 1,000 books to become a better writer, that should fall squarely into that transformative category.
Exactly. That's what the courts are supposed to recognize. The AI isn't competing with the original book. It's creating a totally new thing. This machine reading argument was rock solid. Most experts believe OpenAI was in a very strong position to defeat the Times' original claim.
Okay, so let's unpack this, because this is a monumental shift.
No.
If they had what seems like an elegant, structurally sound, industry-standard defense, a defense that protects all the big players, what happened? What single decision completely unraveled that and put the entire industry in jeopardy?
It wasn't an issue with copyright law. Fair use didn't suddenly fail. It was a failure of discovery integrity. We have to turn our attention now to this really explosive allegation that focuses specifically on OpenAI's leadership.
Including Sam Altman?
Including Sam Altman, yes.
Yeah.
The source material suggests a conscious, preemptive, and frankly, a dramatic strategic gamble was made by OpenAI.
And what was that gamble?
The turning point is the allegation that Altman and OpenAI decided to destroy evidence. We're talking data, communications, internal analyses, things they feared would be used against them by the New York Times in court. They allegedly cleared the stage before the show even started.
Wow. That is an immense escalation of risk. For anyone listening who isn't, steeped in litigation, what is the specific devastating legal term for that? And why does it just trump the entire original copyright argument?
The term is spoilation. Spoilation, in this context, is the intentional destruction of evidence that you know, or you reasonably should know, is relevant to current or pending litigation.
And it changes everything.
It fundamentally changes the focus of the case. It's no longer about the original complaint. It's about the defendant's conduct.
So the court stops asking, did the AI model infringe on copyright? and starts asking, did the defendants try to block the pursuit of justice by destroying evidence?
That is the new battlefield. And if a court finds that spoliation happened, the consequences are disastrous, regardless of whether they were even guilty of the original copyright claim in the first place.
And the court has tools to punish that, right?
Oh, yes. The most potent tool is called an adverse inference.
That sounds ominous. What does that actually do? What's the effect on a jury?
It's devastating. The court doesn't just assume the evidence was bad for them. In many jurisdictions, the court will actually instruct the jury to treat the destroyed evidence as if it proved the most damaging possible interpretation of the other side's claims.
Wait, so the court basically allows the New York Times to argue that whatever OpenAI deleted would have been a smoking gun?
Essentially, yes.
Yeah.
They can argue that the evidence would have definitively proven copyright infringement. The presumption of innocence, at least for that piece of evidence, just vanishes.
And that's where the strategic decision looks just utterly catastrophic. They may have had a strong case on the merits, that transformative fair use argument, but their alleged attempt to control the evidence has now handed their opponent a massive tactical weapon.
It transforms the legal risk entirely. I mean, instead of fighting a difficult but scientifically winnable battle over the nuances of AI, they're now fighting a battle over their own integrity. It's a strategic failure that risks forfeiting the whole game before the main arguments are even heard.
Let's transition to those immediate, really staggering consequences, because the source material is explicit about the potential fallout for OpenAI and for Sam Altman personally. What's the probable outcome for the company based just on this spoliation claim?
The probable outcome, cited directly in the sources, isn't some narrow ruling on copyright. It's OpenAI losing the case specifically on the basis of spoliation. The court could sanction them so severely that the legal battle is, for all intents and purposes, over.
And we're not talking about a small fine. The financial stakes here are they're redefining the AI economy.
Oh, financially, the sources indicate OpenAI may have to pay billions of dollars in damages. That's not just a large fine. That's a liability figure that could fundamentally alter the company's valuation, its operational health, everything.
But it doesn't stop there.
No, the fallout doesn't stop at corporate damages.
Because the alleged act of destroying evidence can shift from a civil problem to a criminal one, correct?
That's the gravity of the situation. The destruction of evidence relevant to a federal proceeding is considered obstruction of justice. The sources say Altman may face indictment for a serious criminal offense.
And the penalty for that?
The source material mentions that he carries a maximum sentence of 20 years in prison.
20 years. Now, that's the absolute maximum, of course, to illustrate the severity, not necessarily what would happen. But the fact that a CEO is even facing that kind of jeopardy for procedural misconduct, it just shows how dramatically wrong this alleged decision went.
It absolutely does. When the penalty for the cover-up could far exceed the penalty for the original alleged crime, it just highlights how much importance the legal system places on the sanctity of evidence. They had a strong argument, a really strong technical argument, and they may have just made it totally moot.
Okay, now this is the section that I think everyone invested in the future of technology really needs to pay attention to. This deep dive is critical because this case is no longer just an OpenAI problem. It's a massive tsunami heading for the entire global AI industry.
That's the real fear. That's why everyone is watching. If this specific loss, a loss driven by misconduct, remember, not by the failure of the fair use argument, is allowed to become some sweeping landmark precedent,
Then what?
it could potentially destroy the fair use doctrine for the entire AI industry.
So let me get this straight. The alleged actions of a few people at one company could essentially void the legal playbook for Google, for Anthropic, for Meta, for every single startup that relies on that machine reading defense.
That is the domino effect. The practical economic consequence of losing fair use is immediate. It would lead to mandatory licensing for all copyrighted training material.
And you just have to think about that for a second. Every foundational model relies on petabytes of data from the public web.
Right?
If every single one of those data points now requires complex negotiations, permissions, payments, that sounds like an instant, massive break on innovation across the board. The cost to build a model would just skyrocket.
The sources are crystal clear on this. The loss of fair use would be a huge setback. It could cost the AI space billions of dollars every year just in licensing fees. It completely changes the cost structure from cheap, fast innovation to slow, expensive bottleneck development.
And it would only favor the giants who can afford those global licensing deals.
Absolutely. This threatens the rights of every major developer, not just OpenAI. The source specifically mentions it threatens Google's right to invoke fair use for Gemini, Anthropic's rights for Claude, everyone relying on that transformative reading analogy.
So even if the courts reject the analogy because of the misconduct of one company, it still impacts everyone else. The trust is gone.
That's the central paradox. The whole AI industry might be technically and legally correct on the principle of fair use. The machine reading idea is sound. But one entity's alleged improprieties could strip that protection from everyone. It's like group punishment for one person's misdeeds.
It creates this enormous tension. The system wants to support technology, but it can't tolerate what looks like trying to obstruct justice.
Exactly. When a company that already has a strong defense allegedly tries to hide the ball anyway, it makes their whole argument, their whole technology, look inherently suspicious to a judge.
So as we watch this play out, what does this all mean? We have a situation where the alleged actions of one party risk fundamentally redefining the global economics of AI, maybe invalidating what everyone saw as a strong, necessary legal footing.
The entire industry is holding its breath.
Yeah.
And the hope, as you can see in the source material, is that the courts maintain a very, very narrow focus here.
They need to separate the two issues.
They need to. The hope is that the judgment focuses narrowly on Altman's alleged improprieties, the specific act of spoliation, and does not use this case to set a sweeping, negative precedent that punishes the entire AI space for those actions.
Right. That distinction ruling against OpenAI for misconduct versus ruling against them for copyright infringement, that is the fine line between business as usual and a global market upheaval.
Indeed. And it forces us to consider a final provocative thought. If the courts do rule broadly against the industry, if they effectively destroy that machine reading analogy, how does that change the future of AI innovation? If mandatory licensing becomes the norm, what knowledge locked behind these high paywalls and complex agreements, what might become permanently inaccessible to machine learners? What's the long-term cost to human progress? That is the question that really hangs in the balance here.